Thank you, Steve. We're a minute ahead, but that's okay. I think we can just get started. So welcome back, everybody, for the last session of the day. I'm Ken Gallagher and a principal planner here at OPD. We have Christopher Bolt and Cordell Johnston returning from sessions that you all attended this morning, and Stephen Whitley has been at some of our previous conferences. So we can just go right ahead and get into some of the questions. We have some good ones that have been coming in during the break. And but first, I'd like to go back and return to, I think there might be a couple questions that we did not answer during the morning session. So let's just go ahead.
And Ken, I'm not sure if you saw Steve's request that you activate his camera.
I see that. Okay, me just a moment. Hang on a sec. There we go. Let's see if I can do this. There we go.
Wonderful.
Excellent. Okay, great. Good to see everybody here. So let me go back to the morning sessions first. Some of these I know you answered a lot of them. I'm not sure if maybe I missed a couple ones that you might have answered. So the first question that I did not mark as being answered, what would the process be if the applicant years later wants to ask to modify the conditions of approval of the variance?
Yeah, I think that was my question, and
That's right.
I said that they need to come back,
Okay.
and Chris or Stephen can speak up if they disagree with that. But basically, they've gotten a variance, and now they want something different. I don't see any process other than a new variance application.
Correct.
Okay.
And Steve needs to be unmuted also, Ken.
Oh, not again. Okay, sorry about that.
Steve can unmute himself now, Ken. He's a presenter.
Okay.
Steve, can you try to unmute?
I don't know if he is a presenter.
Yeah, we don't take control of this one.
Hang on a sec. I've lost.
He's right there at the top. He's within the presenters.
There he is. Yep. Okay. Whoops.
Raising his hand.
Got it.
Here, let me.
Technical difficulties beyond our control.
I'm getting.
Steve, I'm going to try to make you an attendee and then unmute you. You can't unmute yourself, can you? Oh, it doesn't seem like you can.
Okay.
Allow mic. Allow camera. Steve, can you try to unmute yourself now?
I'm getting some weird icons on here saying that
we can see him. It's just that I can't. For some reason,
I only have an option to disable his mic.
No, he has to do it on his own.
Yeah.
We'll throw all the hard questions to Steve then.
Steve, go under your mic. There's a drop-down menu under your mic or next to your mic. And then there you can choose which one.
Audrey, that was not nice.
Okay. Alvina, do you think Steve should log out or leave the meeting and come back in?
Yeah, we can try that, Steve, if you don't mind.
I think we were close.
Okay, he's gonna do that.
Okay.
And if that doesn't work, I can try to invite him over with his email. I'm not sure if that'll work.
Yeah.
But you can keep going.
Yeah, okay. Another question that may have been answered during the first session. When does a ZBA approval expire if the project doesn't get underway?
That's the 2-year use it or lose it rule.
Okay.
That does have that weird and very cumbersome language. It shall not lapse for 6 months if the planning board approval is needed.
Okay.
To the best of my knowledge, we don't have a case yet interpreting that. Definitely not from the Supremes, and I haven't had one at the Superior Court. Cordell, not sure if you have anything.
No, no, I haven't. And the only thing I'd add is it's 2 years, but I believe the town in its zoning ordinance can make it longer than 2 years if they want, but the default is 2 years, right?
Correct. And my advice on the private side of life has always been, you have to have started. You have to have gotten pull your building permit, start the work. I don't think you have to complete, but you have to have more than just one shovel in the ground.
Sure. Yep.
And then you prosecute to completion. You don't start it and then stop and go away for a year and a half.
Okay.
Steve, I'm gonna try to call you in for audio. Maybe that'll work. Might be some echo. But at least you'll be in the. I'm calling the phone number we had for you.
Okay. All right. Next question. This one was kind of asked in jest, I believe. When you were talking about notification and you mentioned making announcements in newspapers, somebody asked, what is a newspaper? But I think it's actually probably a valid question. Are there problems now with lack of newspaper coverage in certain areas? Are there alternatives to announcing in a newspaper?
Is this talking about notice of hearings?
Correct. Yes.
Yeah. At least the towns I represent have not had any issues with that. I think the union leader is basically available everywhere in the state, but if not, all the areas that I'm familiar with have at the very least, some kind of local paper, maybe just a shopper. And if it is only a weekly, then it may be more difficult to get it timed right. But I don't think there's any place in the state where there isn't some kind of traditional newspaper.
Right.
Okay.
And I agree. There is, I thought at one point in time in this legislative session, there was a move to remove that requirement of a newspaper. And I believe that got weeded out in the mix. I don't think we have a live bill pending with that still in it.
Yeah, years ago when I was at the municipal association, we got annoyed with the newspapers because they were always on the wrong side on right to know law issues. So we tried to get that newspaper publication requirement taken out, but of course the newspapers came out and opposed that and killed the bill. So it's still there.
Okay. Thanks. I see we're still trying to get Steve unmuted. Apologize for that. And I'm hoping Alvina has another solution for us.
I am trying to call Steve because I got the number
Okay.
that I called in the chat,
Okay.
in the meeting, but I don't know if that's his number or his work number.
Okay. Okay, fine. I'm going to continue with questions that were in the first session. And I know the next one, there was some discussion about recusal, how that's done. I don't know if this particular question ever got answered. So let's say if a person who, the question is, if a person who should recuse, the should is in quotes, if that person refuses to recuse, and that was all discussed, I remember, could this be grounds for the applicant to appeal whatever decision the ZBA renders?
Yes, absolutely. And that's the whole point of it. If you are prejudiced, or you're in a butter, or you have some kind of stake in the matter, you need to recuse yourself, because even, as I said, even if there's a 5-0 decision and you weren't the deciding vote, there's almost a 100% chance that decision is going to be reversed if someone chooses to appeal it.
At the very least, remanded.
Right? Yeah, remanded.
Because the courts will take the 20/20 hindsight view.
Mm-hmm.
Yep.
Okay. Here's a question that should be a really quick answer. In terms of days, are we talking calendar days, or are we talking work days for that days of that a decision should be made, whatever?
Yeah, the 5-day notice is, well, in each case it's calendar days.
Yeah.
I don't think any of the periods that we're talking about are business days.
Now, I believe only in the 91A world will we
Right.
get to count the business day.
Okay. Continuing. Let's see. Continuing, is an equitable waiver substantially complete clock started when the abutter complains to the select board, or when the select board sends the cease and desist?
Interesting. I'm not sure. Ooh, now we got an echo.
Does that mean, hang on a sec here.
That's
Steve,
Steve, but
maybe
he called in. We'll
connected.
just have to, yeah, something has to be turned off. Maybe muted here.
It
enough.
seems fine now.
Yeah, now it looks like he's offline again, unfortunately.
Oh, okay.
In short, I know there's no case on that. I have, I guess I would view it as when is the property owner, who would be the recipient of an equitable waiver, notified of the issue. I've dealt with a few on both sides of the aisle over the years. One, the complaint was issued after the house was complete, and it was like there was never a cease and desist from the town. It was the abutter filed saying he's a foot too close to the line. On one from the municipal side of life, the issue was the foundation was poured, and that was the trigger event, and the builder basically stopped while went through the equitable waiver process. Ultimately got it, and again, it was a few inches over the line for that ZBA to handle. Not sure I answered the question, but I hope I did.
Okay. All right. That, I think, is everything from the morning sessions. So there's quite a few that have been coming into the chat, so we will continue with those. First question, in an application for a variance, if the applicant does not provide their answers to the 5 criteria needed to grant a variance, can this be considered an incomplete application?
And I'm assuming they didn't do a C attached and provide the letter and the plans. I've never had that bad of an application before. I guess the answer is you could. It was definitely one of those things I would hope your staff would pick it up and go, you got to tell us how you're meeting these 5 criteria. Oh, Steve's back because I've got an echo.
Yeah.
Excellent. just to repeat the question for Steve, if you have anything you want to add, in an application for a variance, if the applicant does not provide their answers to the 5 criteria needed to grant a variance, can this be considered an incomplete application?
Can you guys hear me?
We can.
Yes.
Oh, okay.
And we don't have an
okay.
echo. Hot dog.
Yeah, I turned off my phone. I somehow got it at work. Apologies, and thank you for everyone for being patient. Ken, can you repeat the question? I'm sorry.
You bet. In an application for a variance, if the applicant does not provide their answers to the 5 criteria needed to grant a variance, can this be considered an incomplete application?
I mean, the ZBA doesn't have a completeness determination to make when they're considering applications. And so I suppose they could say we don't have enough information to evaluate the request, but it might be cleaner to just say you haven't provided evidence to satisfy your burden, and so we're going to deny your application.
Well, but presumably when they, I mean, you're not saying just deny it without a hearing, are you?
Oh, no, definitely not.
I mean, presumably when they come for their hearing, even though they haven't put it in the application, they will explain orally, here's why I meet all of these criteria. So, yeah, I'd be inclined to agree that the first thing is to go back to them and say, do you want to put some more information in your application?
Right.
And then, and hope that they'll do that. But if they don't, you probably have to proceed and hope that they will make the argument at the hearing.
And from my perspective, anything that you're denying for that kind of procedural issue, I would suggest be a denial without prejudice. So you're not creating a Fisher v. Dover issue.
Right. Yep.
Sounds good. So the next question, looks like, Steve, you answered it in the chat. Let me go ahead and read the question in case it provokes some more discussion. The question is, question 5 of RSA 674-33, stumps members of boards. Can you explain in plain or layman's English what this means? And then no fair and substantial relationship exists between the general public purposes of the ordinance provision and the specific application of that provision to the property.
I'm happy to try. From a standpoint of the unnecessary hardship, I think it's easiest to break out 5A into 3 segments. 1, what are the special conditions of this property? That we know, okay, it's got this configuration of uplands and wetlands, as built, road frontage, lake frontage, whatever it's got. That second one is you're really needing to look at the specific purpose statement for the zoning provision the variance is being applied to. For example, if it's a setback, the side setback, in all honesty, there's never a zoning ordinance that says why we have a side setback. But you can have some general implied purposes, such as provide space for air and light between buildings, privacy, fire protection, that kind of thing. And what is the purpose of those provisions applied to this property in its environment? And the third of the 3 prongs is the project reasonable? And as I've quipped for years, it's much like beauty. It's in the eye of the beholder. You know, if you're trying to shimmy the Romney compound into a 1/4 acre lot, that may not be reasonable. If you're trying to put 5 additional feet on a deck on the side setback where the neighbor next door is actually on the far side of their lot, you know, maybe that's not a problem. That is reasonable. But it's the board's conversation about that, and most importantly, making written findings. And as I and others have always said, use because statements. We find that it's reasonable because we find the special conditions of this property are X, Y, and Z, those specifics.
Thanks. Steve, you actually answered in the chat. Would you like to just sort of tell us what you said?
Yeah, sure. I mean, it's going to be a little bit repetitive to what Chris just spoke of, but basically, you know, what they quoted was the fair and substantial relationship part of the test, and I look at it as the ZBA needs to figure out what is the purpose of the zoning restriction you're talking about, which is what Chris was just talking about and using setbacks as an example. You know, if the purpose is to promote air and light and perhaps to mitigate the danger from fire spreading, you know, if that, then you look at whether that purpose is advanced when you apply that zoning restriction to this particular property you're dealing with. And if the answer is yes, that purpose is advanced, then there may not be a hardship, and that applicant may not get the variance. If you apply that zoning restriction to the property and the purpose is not advanced, then you need to, as Chris mentioned, look at, you know, is it not advanced because of those special conditions on the property? And if so, then there probably is a good reason to say that they have satisfied the hardship element and they may be entitled to a variance.
One adder, if I may. Remember that we are no longer in the BOSHA world, which had a necessity element in it. I think we have some of my client boards are still wrestling with that. Well, they don't need a garage, you know, and it's like, well, guys, wait, that's no longer the standard. We're talking about special conditions. We're talking about the express purposes, and we're talking about, is it reasonable? Look at those three things and try to keep necessity off of the buzzwords.
And I think part of the problem is the word hardship. That if I were king, that would be taken out of the law entirely, because people see that word and they say what Chris just said. Oh, you don't need this. There's no hardship here. I advise my boards to forget that those words are even in there and look at what the statutory language is, special conditions, the relationship to the purpose, and is it reasonable?
Right.
And I think that works better if you get the concept of some kind of hardship out of your mind, unfortunately.
Right. And that dovetails nicely, Cordell, with that opening clause of Section 5A, where it says unnecessary hardship shall mean
Right.
blah.
Yeah.
And so it is. It's. I wish I could Velcro over that clause.
Yep.
Okay, thank you. Next question comes from Barbara. And it says, if an application comes before the ZBA for an area variance for a setback, but is also partially in the floodplain, does the ZBA need to address the floodplain issue even though the application is not for a floodplain variance?
I would say that the ZBA can flag that issue for the owner, the applicant, and ask them if they want to amend their application to include a variance request for the floodplain. If not, you know, if they decide not to do that, then they're probably not going to get their building permit or whatever else they may need, because there's still a zoning violation out there that has not been addressed yet.
And
But I don't think the ZBA can force them to seek a variance. I think they can They can alert them that they need one, but it's really up to the applicant. And I don't know why they wouldn't do it, because like I
Right.
said, they're leaving an enforcement issue sort of hanging out there.
And it also depends upon the language of the floodplain ordinance, because some are written not as a prohibition, but as if you're going to build, you have to build this way. And so that language needs to be looked at. It may come in to the public interest spirit of the ordinance prongs. It could come into this fifth provision on, is it reasonable? But I agree, it probably needs to be addressed somehow. And maybe through a condition, we grant this, but you've got to comply with the floodplain ordinance provision XYZ, or come back to us for a second variance.
Okay. I have a long question here. I'm not sure if I can read the whole thing in one go. Let me just start and see where we're going with this. This is regarding appeals. And the questioner says, please confirm that the term appeals as applied to the ZBA oversight refers to variances, special exceptions, equitable waivers, as well as appeals of administrative decisions. This derives from RSA 676.5, which states in part, appeals to the Board of Adjustment concerning any matter within the board's powers as set forth in RSA 674.33, which would include 674.33A, correct? Let me know when I need to stop. Is there anything you can answer yet, or there's more?
But wait, there's more. Call before midnight tonight, and you two can have.
It's in the chat. I don't know if you want to look at it. It might be
Yeah,
easier
I
if you all
found it.
just sort of
And
looked over it.
while I agree that the appeals is in that statute broadly would encompass everything under 674.33, I'm a little flummoxed by the fact that they don't refer to 674.33A.
Yeah.
But I've always treated it in practice as that's one of the things that's before the ZBA. So you have to still follow the procedural issues contained in 676. You don't, the equitable waiver doesn't have a different motion for rehearing statute applicable to it. It doesn't have a different appeal route given to it.
I didn't mean to cut you off, Chris. I was just going to add that it looks like the legislature tried to address that on the back end, because the equitable waiver statute actually has a specific paragraph that talks about application and hearing procedures. And
Right.
it makes reference to it being governed by the admin appeal statute, 676.5.
You're right.
Yeah.
Yeah, so they back end it.
Yeah.
Okay. Does that pretty much cover? He has three more questions sort of related to that. Do you feel like your answer that you've given so far applies to what his subsequent questions are, or shall I read them out?
Well, the time limit.
Yeah, looking at the first question, I mean, it is kind of an awkward concept, because the statute talks about appeals, and I've heard some people suggest that you can't just apply for a variance, that you have to first apply for a building permit and get denied, and then apply for a variance. I think in practice, nobody really follows that. And the first question there is about a situation where a property owner reads the ordinance, says, oh, I need a variance. So, and then just goes and applies for a variance. So they're not actually appealing from anything. And the question there is, in that case, I think the question there is the time limit for appealing doesn't apply. And I would agree with that because there's nothing to appeal from.
Right. And in my representation of the forces of darkness in various communities on the developer and abutter side of life, it is one where different towns do it differently. Moultonborough, for example, has an express provision. You have to do a pro forma building permit application to get a zoning determination to then go to the ZBA. That has been their practice for the last couple years. To me, I'm one of the old school that says, I know when I need a variance, just let me go get ask for the variance. I have the plans that clearly show I need a variance, but different towns do it different ways. And as long as your rules of procedure are clear, I think both ways are fine. Having a variance come to you directly or having a variance have to have a zoning determination. Now, what I haven't seen is the zoning determination is given, therefore you have to file your variance application within X days.
Right.
That's where there could be kind of a gotcha. Now, most of the time, if it's, I'm on the private side, I've got the client that is, frustrated at this intervening step. So we're definitely filing the variance application on short order once the zoning determination is made. I would flag here also that one of the pending bills, which damn one was it? Senate Bill 78 that is still pending is going to be changing that within a reasonable time of 676.5 to within 45 days. So it's going to remove the flexibility that I think runs from right now. The shortest I know of is 14 days and the longest is 65 days.
Right.
Okay. Great. Well, thank you. I think that's some good advice there. I have several more questions. Next one is, are there any model zoning ordinances and meeting procedural guidelines available for typical small towns?
Yes. You guys have them.
I believe that's us. Yeah. Yep. You can start on our website and then you can also contact us.
Right. And the other thing that I suggest to our client towns is talk to folks that are right near you. What's working for them? Rather than incur a bunch of fees with us, find out what you want, but then run by your final draft to us so we can confirm that there's nothing that's conflicting or having an unintended consequence.
Sounds good. Next one. Can an individual unit owner apply for a variance because he wants conditions imposed under the variance granted to the condominium complex as a whole changed specifically for his unit, maybe, for instance, due to a disability?
I guess I didn't quite follow that. I'm going to see whether I can.
So apparently the person perhaps would want conditions imposed changed for specifically just for their unit, perhaps, because of a disability.
So
I think you've got some conflict. I'm sorry, I cut you off, Cordell. Go for it.
No, go ahead. If you understand the question, go ahead.
I think I understand, but I'm not positive. So Nancy, put something later on in the chat if we've got it wrong. If a condo unit owner is wanting to get their condo declaration bylaw restrictions modified, going to the ZBA is not the right forum. In fact,
I don't think that's the question though, Chris.
Okay,
And I agree with that, but I think they're saying, assuming when the condominium was approved, there were conditions imposed by the, well, in this case, the ZBA, or when it was allowed, there were conditions imposed. And now an individual condo, an individual unit owner wants to get rid of that condition with respect to his unit. I think that's the question.
okay. Huh.
Can they do that? Can they apply for a variance, maybe due to a disability?
Well, we have the provisions for disability variances under the statute. The issue would the unit owner have standing to seek a modification of prior conditions applicable to everything? That seems to be, let me drop back and punt, even though it's second down. I think that one's so specific and unusual a circumstance that it's beyond the hypothetical guideline that we normally want to have in these Q&A sessions. So I think you want to run that question by your town council. And if that happens to be my firm, feel free to call and we'll figure it out. But
If it's one of my towns, call Chris's firm anyway.
Okay,
I'll say, I think the answer to that may be yes, but that's a maybe. So
Yeah.
don't go by that, please.
yeah, it's definitely a bit of a quagmire. My hope would be especially if it's a disability situation, that the condo association comes in as a co-applicant, supportive of the issue for that unit, and it's not modifying everything.
okay, great.
Another day in paradise.
That's right. Another question. Is it correct that conditions cannot be put on appeals for equitable waivers?
I'm going to punt that to you guys.
Put it this way, I'm not sure of anything in the statute that would prohibit it. I'm looking real quick. I think you're going to be under the same guidelines applicable to any variance or special exception, or even appeal of administrative decision. It has to be tied reasonably to the facts in issue. I'm not sure that I've seen a condition on an equitable waiver. Where I know we see them all the time on special exceptions, variances. I've even seen them on some of the short-term rental appeals of administrative decisions. Where,
Sorry, Chris, go ahead.
Where, it's reasonably tied to the evidence that's presented to the board. What were you going to say, Steve?
I was going to say, I think there's an argument to be made that you cannot do conditions on an equitable waiver, because remember, equitable waivers, they're not dealing with questions of use. They're dealing with dimensional infractions, and so the process for an equitable waiver is: are we going to grant forgiveness for this dimensional infraction? And so I don't think I'm trying to think of a situation where a condition would be necessary for something like that. And I'm having a hard time coming up with that. And I know that the authority for conditions on a variance, there's some case law that talks about that. And
Right.
special exceptions, it's expressly in the statute that you can put conditions on a special exception. And I'm not aware of anything like that for equitable waivers. And so it's an open question is maybe the
Yeah.
safe.
I agree. It may be well an open question. One that I could see, however, as a condition is because you are closer into the setback than you're supposed to be. It's the whoops rule is what I call it. Could there be a condition based on the circumstances of the adjoining lot to say, okay, you're not going to be able to come forward for further expansion on that side, for example? You know, maybe. And I guess the best answer we can give would be maybe. But I know there's no case law out there saying yes or no on the conditions.
Okay. All right, going back to recusals here for a moment. Is there any personal liability for a ZBA member who refuses to recuse after an appeal is made to the court and the ZBA is reversed?
So they're refusing to recuse a second time?
No, I think it's for the first time.
Yeah, I think the question is, I refuse to recuse myself and the decision gets appealed, the Superior Court reverses or remands. Can someone sue me because I didn't recuse myself? I think the answer is no. You're not subject to any kind of personal liability. In fact, under RSA 31 something, the statute expressly says that board members are not subject to any kind of liability for actions or decisions made in good faith. I suppose one could argue, well, you didn't make that decision in good faith. You knew you should recuse yourself and you didn't, and that was very clear. But I guess the question is, what would your liability be? First of all, who would sue you, and what would your liability be? Because the case came back, probably because you should have recused yourself and didn't, you're going to end up with the result that the person complaining wanted. I'm not sure there would be any liability, and I think in any event, except in the most extreme abuse of discretion case, I don't think you would have any personal liability. But you're doing a very bad thing for your town if you're refusing to recuse when you should have. And if you're an appointed member, there's a good chance that you won't be reappointed. And if you're an elected member, there's a decent chance that you won't be reelected. So nothing good can come from refusing to recuse yourself.
Right. And under the provisions now that we have under 67720, which is the fee shifting statute,
right?
You know, while it's leveled at the board may be responsible, acted with gross negligence, in bad faith, or with malice. So, you know, that is a risk on the first failure to recuse. And if I read it correctly the first time, that we're really talking about who refuses to recuse after an appeal is made to the court and the ZBA is reversed. So it's the second recusal. I think you definitely open yourself up.
Yeah.
And keep in mind that while I've never seen one, there's always that risk of the town is the defendant and the town brings a third party action against the failure to recuse person. To say, look, if we're tagged with fees, it's all on that person.
Right.
Okay, thanks. Here's a question about timeliness, I guess. This person's procedure, their town, is that all applicant information and paperwork be submitted 10 business days prior to the ZBA meeting. it happens a bit too often that an applicant submits something late. Can the ZBA refuse to accept late supplemental submissions when the application has been filed on time, or set a continuation based on late submissions? Also, does the chairperson have the option to accept the late submission so as to not prolong the case? And should the ZBA members be polled on whether or not they want to accept the late submission?
I think that if the record is still open, that I don't believe the ZBA should be refusing to accept submissions. And so if the applicant or the abutter doesn't comply with that 10 business day requirement, I think they still get to submit the information. It just may be the ZBA has to continue that application until they've had a time to review it. And yes, I mean, maybe in some instances, the late submission is fairly small or easy to, digest. And so even though it may not have been submitted, 10 business days before the hearing, the members could indicate that, they're willing to waive that requirement and consider that evidence as part of the application. But I would think that's more of a board decision than a chair decision. But I guess you could handle it either way.
I agree.
Sounds good. During deliberation, can a board member ask for a clarification from the public or requester?
Certainly, but if it's, I think it needs to come to the chair, and the chair then calls for the motion to reopen the public comment period to ask the question and have it be limited to that question. But remember, whoever else, the abutter is being asked the question. Great, they give their answer. The applicant has the right to respond. Wait a second, that's not what happened here, or we agree with her, or whatever. So that it's both sides have that opportunity, and then you close down the public hearing again.
Yeah, and that's why I said this morning, you should try to get all of your questions answered before you close the public hearing.
Right.
Because once you're in deliberation, that question comes up, and then, as Chris said, you have to reopen the public hearing. And what if people have left? You're in kind of a tough situation. So yeah, I agree you can do it, but try very hard to get all your questions answered. And I mean, I understand that sometimes you get into discussions and a question comes up that no one thought of, but try as much as you can to get all of those answered before you close the hearing.
I definitely agree there. And if I can add a caveat, I am very frustrated if I'm there at a meeting on a contested case and somebody has not asked a question I knew they had. And it's kind of the hide the ball. So I'm gonna raise this issue in deliberation when nobody can respond to it. I loathe that. Let everybody, raise your questions, hear it out. You don't have to be convinced by what somebody says, but at least the benefit to the rest of the board is you've asked your question. It's gotten some response some way or another, or, heaven forbid it's ignored. You then the record is clean, and you can then use that as a because statement if there's a move for denial or approval.
Okay. Thank you. I have one question, which is just a follow-up to the number of days, how they were determined. The answer was calendar days. The follow-up question is calendar days, including holidays or plus holiday?
Depends on when the holiday is.
Yeah, I mean, I think it's, so if someone, if you make a decision on June 30th, and someone then has 30 days to request a rehearing. So they have until July 30th. There's a holiday in there, Independence Day, but that doesn't give them an extra day.
Right.
They just have 30 calendar days, period. Now, Chris said it depends on when the holiday falls. If the decision was on June 4th, 30 days now would be July 4th. And because that's the day that the town offices presumably are closed, you get to the next day. So yeah, if the last day to do something falls on a holiday, you get kicked over to the next day. But if it's in the period, it just counts as a day.
And another caveat, if that next day happens to be a weekend, it falls to the next business day.
Right.
Thank you for that clarification. Yes, that's good to know. This is another, I think, a clarification. So the question is, if an application is incomplete, quote unquote, then the ZBA can refuse to schedule a hearing for it. And there's 2 question marks at the end of that question.
Yeah, I would caution people about refusing to schedule or open a hearing, even if you don't have enough information. Because again, the planning board has a statutory process for determining that an application is complete, and there just isn't a corollary for ZBA applications. And so, I suppose in your local rules of procedure, you could specify the bare minimum of information that you're looking for, and you could sort of create a completeness determination in your local rules. But if you haven't done that, or even if you have, I just would caution people about refusing to allow an applicant to come before the board and fill in whatever holes there may be before the ZBA takes any action on that.
Okay. Good to know. Next question. An applicant submits a variance for a use that is not in the zoning ordinance and for which there is state legislation on how this use should be permitted without undue requirements. An example, accessory use of solar on commercial property. Do you have any suggestions on how to address the criteria, specifically hardship?
Well, I'll step on the third row. I think it is one where those statutory confines, and the one that I've dealt with most frequently happens to be in the cell tower world where the TCA comes into play, that you have to take that umbrella statute into play. And sometimes that means there is more flexibility on those specific items than there would be on the commercial use in a residential zone variance or the deck coming into the side setback variance. It's going to be very fact specific. And again, this is one where if faced with that situation, touch base with your town council.
Okay. Onwards. Another question under variances. For the hardship question, if they submit a mitigation attempt for the variance, but they still could meet the ordinance and are choosing to offer mitigation instead, is it still fair to deny for not meeting the hardship criteria?
If I'm understanding the sort of hypothetical, then I think it is still fair, because you either meet the various elements of the variance or you don't. And so if they haven't presented sufficient information to establish that, then they don't get their variance. I could be misunderstanding that, but that's my sense of it.
Well, the way I'm reading the question is I'm applying for a variance and I could do something close to what I want to do without a variance. But I want to do what I want to do, and so as part of my variance application, I'm suggesting some mitigation effort.
Got it, yeah.
And can the board say, well, you could do it this way without violating the ordinance, and because you could do that, there's no hardship, and therefore we're going to deny the application. If that's what the question is saying, I'd say no, because you're back to the argument, you don't need a variance.
Right. Yeah.
Or you don't need to do it this way. You could do it that
a necessity issue, right?
Yeah.
And
Yeah.
the two, I agree with, I think I agree with you, Cordell. And the two cases that are coming to mind that I think answer the question in support of you, Cordell, would be Malachi Glen, which was the self-storage units wanting to come in after the wetland buffer ordinance is put in play. And the old Vichant case, which has been cited since the statutory change, which was the 5 multifamily units in a zone where the multifamily was allowed, but the setbacks on the 2 acres were such that they had an incredibly small building envelope. And the problem there is the ZBA got into some horse trading format and said, we'll give it to you if you do only 3, and the owner wanted 5. So I'm concerned with what could they do? Because again, as my analogy is, you're the constitutional safety valve per the Simplex case. You know, there is tension between the police power and the private property right. And if you're coming in like Malachi Glen did, doing all those bells and whistles of a drainage system that met or exceeded what the buffer was going to do for it, or if you're putting in all those rain gardens and swales and plantings that DES wants you to be putting in for a lake setback issue for that deck, and the board is saying, well, you really don't need that 12-foot deck. You can make do with a 6-foot deck. And guys like me can't walk around on a 6-foot deck. I've got too much girth. So it's where is that reasonableness line, considering those 3 prongs of the hardship test that we've discussed already, and wanting to Velcro over the phrase unnecessary hardship.
Right. And just to be clear, I wasn't disagreeing with Stephen. I think we were answering different questions there.
Yeah.
You guys can disagree. That's okay.
Okay. Sounds good, though. Let's go ahead to the next question. So a person goes to get a building permit. The building inspector says they need 4 variances. When reviewing the application and holding the public hearing, the ZBA determines that an additional variance is required. Can the ZBA make obtaining the additional variance a condition of granting the variance requests?
I have had even the worst case scenario with that question. I have had a building determination saying I needed those 4 variances, and the ZBA comes back and says, you don't need any of those. You need this one over here. And I literally had to make that on the spot determination of trying to figure out, is the one over here the lesser included, to borrow a phrase from the criminal justice system. So it's included in my relief I sought on the 4. I think the answer may be, if you're going to make that change away from what staff did, you want to be on very solid ground, but also not be an absolute southbound end of a northbound horse to the applicant. You know, if it's can be argued, there's no change to the notice needed to the abutters. The project is the project. The notice was given to the abutters of the project saying variances were needed for X, Y, and Z provisions, and you come out with, no, you needed AA on your own. I wouldn't screw around the applicant. I would, if they can meet the criteria under what's been presented to you, great. If not, continue to a date certain and allow the applicant to come forward with whatever they're needing there. But rather than deny it or say you've got to come back with a new application because we don't like the fact that you followed staff's recommendation, that doesn't play well with Judge Klaas.
I think my answer would be that I'd be uncomfortable with any of my ZBAs tacking on a condition that the applicant needs to seek an additional variance. Because again, I think that's more of an enforcement issue. You know, the applicant, you know, for whatever reason, they may decide they don't want to amend their application. They don't want to do it right now. They may disagree that they actually need that variance. I'm uncomfortable with a ZBA making a condition like that because it seems to me as unrelated to the variances that the ZBA feels like are warranted. And so, you know, if evidence has been presented that 4 out of the 5 variances should be granted, then they should grant them. And if there's one left outstanding, then again, I think that's more of an enforcement issue and not a condition of approval for those other 4 variances.
Yeah. Okay. That's great. Thank you. Continuing on, I'm skipping over, looks like there's basically some people answering one another. The next thing that looks like a new question to me is, so this is a follow-up to the recent question pertaining to what is a complete application. So is it procedurally acceptable that the ZBA can rely on verbal or written testimony provided during the hearing to complete the application? So that, in other words, that is that the applicant does not need to go back to provide information lacking on the application.
I think they can.
Yeah. I agree.
Okay.
Yeah, I think that goes back to Stephen's point that there's no completeness determination required. If someone files an application, there may be stuff missing there. You don't reject the application because it doesn't have everything in it. Yeah, they can supplement that by oral testimony or something else that they submit at the hearing.
Okay.
And I'm sure we've all seen, you know, the instance where the person tries to do it themselves the first time, they get a denial, the motion for rehearing comes in from an attorney who knows what's going on, submits everything that should have been submitted the first time, answers the questions that were asked that the applicant couldn't do. That's the instance where the motion is granted. You come back through, have another hearing, you know, let it be complete, rather than force somebody to go up to Judge Klaas and have it kicked back.
Mm-hmm. Okay. There was some discussion going on following up with equitable waivers. Maybe I should just see. I'll bring them up because it might be able, you might be able to comment on them. So, for instance, why couldn't it say no floodlights into the neighbor's yard since we are letting you keep your setback infraction? Another one, condition might be to prohibit further construction in the area that is non-conforming. Is that correct? And I'll do the third one. What happens when such a waiver is complicated by the applicant not having completed steps in the permitting process where the mistake could have been caught before starting construction? So those are all examples.
I think the cleanest answer comes to the third, which may mean that they don't meet the first of the criteria. Where someone hasn't applied the right way or didn't apply at all, and now is here, they may have a harder time, because I've viewed the equitable waiver rule as something where there was an honest mistake. And I believe there is a 3JX decision on equitable waivers. Let me hold on, see if I think I cited it in my materials. The RDM Trust v. Town of Milford case in 2016. Now, it's a 3JX decision. Docket number 2015-495. So it's on the court's websites under 3JX, meaning it's non-presidential, only 3 judges weighed in on the case. It was error to affirm the ZBA's grant of an equitable waiver where it was not based on the owner's error in a measurement, but rather a conscious decision to hold the non-conforming line of another part of the building. I think that may come into that, by analogy, your issue of not going through the permitting process.
For the other 2 questions there, I'm going to stick to my guns and say you can't put conditions on an equitable waiver, and say it's an up or down vote on those. And there is some language in the test for a waiver, but whether it's warranted or not, about the violation constituting a public or private nuisance, diminishing the value of other property, or interfering with or adversely affecting present or permissible future uses. And so some of the hypothetical conditions, I think the ZBA would get to some of those in evaluating that language that I just read from the equitable waiver test.
And a caveat, I'm now thinking I'm coming to your side of the aisle, Steve, with the language and the disparity between the 2 sets of statutes. More importantly, when somebody would be coming forward for future construction in that zone, that's going to need a variance. Mm-hmm. And the conditions may well be, hey, wait a second, you got an equitable waiver for this over here as a whoops. We allowed that, but this is arguably too much for spirit of the ordinance, public interest, no diminution of property value. Is it reasonable and substantial justice? Prongs can all be hit with that potential issue.
Yeah, and just to piggyback on that, I mean, remember that if you get an equitable waiver, that's not considered a vested, grandfathered, or non-conforming use.
Right.
You don't obtain that sort of protected status by virtue of getting the equitable waiver.
Right.
Excellent. Thank you. I have one last question here in the chat. And the question is, can the application not be heard if the applicant does not attend the meeting?
Nobody from the applicant shows up, I have a problem. The applicant themselves, but their engineer, their surveyor, their lawyer shows up, to me, that's not a problem.
Right.
But if
I
think I would ask and just want to double check that the notice to the applicant's team was correct, and just make sure that the addresses were right, or whatever means were used, that they should have known that the hearing was that evening, before going on and considering the application.
And depending upon the nature of the beast, it may be advisable to continue to a date certain so that you can double check. Did somebody get in a car wreck and they can't be there? Did someplace, spouse go into the hospital that night? Whatever. Rather than a get your nose out of joint and, I'll teach him, I'll say no.
Yeah, I tell a lot of my boards, if we can, be sort of more understanding on the procedural stuff so that we allow an application to be heard and a decision made on the merits, that's a much better position to be defending a decision than saying, you didn't show up for when your hearing was scheduled, and so we voted not to hear your application, and you basically need to apply all over again. Or if it's a denial, a flat denial,
Yeah.
I just think you're in a much better position to defend if it's a decision on the merits rather than a procedural decision that's kind of in a gray area, maybe.
And another to piggyback, as you say, Steve, if there is one of those egregious circumstances out there, you're going to get a motion for rehearing that you're going to grant.
Yeah.
And, why not kick them out to the next meeting, instruct staff to reach out. Hey guys, you didn't show up last night. We continue to next Thursday. Got to show up or this one's gone.
Yeah.
Kind of thing. You're in a much better position.
I would, I agree completely, but along with that, I would also insist that the applicant agree to waive the requirement of a decision within 90 days because it's their fault that it's taking
Correct.
us long.
Yeah.
Correct.
Okay, that's a good answer. We're under 5 minutes now. One more question has come in, so let's do that. So regarding the written decision requirements, oh, another one just came in. Okay, 2 questions. That's the last 2. Regarding written decision requirements by a ZBA, doesn't RSA 676(3) limit the requirement to decisions which either approve or disapprove an application for a local permit, and not necessarily decisions on an appeal of administrative decision? Refer to Part 1 of that RSA.
The statute does say an application for a local permit, which I think is not the clearest language. But if it's an appeal of an administrative decision, typically the administrative decision that's being appealed is a denial of a building permit, or I suppose the granting of a building permit. In either case, it's a local permit. So I think that the written decision requirement still applies. I don't know whether Chris or Stephen can.
I agree. I read 676(3) broadly to include, decisions that come from an admin appeal.
And it's, remember, the opening clause is any land use board.
Yeah.
So the language intends to capture not only the ZBA, but also the planning board, any other land use board your town may have. So I wouldn't get hung up on, well, it doesn't say a notice of decision for a variance, special exception, or whatever. I think these provisions, especially in light of the language that came in as a result of House Bill 1661 and 22, you've got to have the findings, especially if there's a denial, because it's an automatic remand if you just say, we deny your application.
Okay, we have one last question. This will be the last one. Different subject, does a ZBA create a spot zone if it approves a high density residential / mixed use project in a commercial zone that prohibits residential use? Is that a spot zone?
Well, all you have to do is wait 2 months and see what happens with the legislature that is about to make Actually, I think that one passed. Yes, House Bill 631 has passed and is on the way to the governor. That makes it mandatory to allow multifamily mixed use in all of the zones.
Wow.
So your spot zoning is possibly removed by the legislature.
I would
And-
add, even if the legislature hadn't stepped in to do that, I don't think that's spot zoning. Because if they're seeking a variance or a special exception, that's specific to that piece of property, and there's certain, obviously, elements that have to be satisfied. And if they meet those elements, then they get the relief. They get the
Correct.
variance. They get the special exception.
I agree with Steve, and Audrey's correct. I misstated. It's not all zones, it's all commercial zones.
Okay, and that I think will cover it. I want to thank all the people who are attending and some really good questions and some good discussion here. Here's some contact information for our three speakers. Thank you all for taking your time to do this. Let me see what else is on these slides here.
Many thanks to you, Ken, for all the work and the whole team, and appreciate everybody showing up on what has been a rainy day and looks
Yeah.
like it's brightening.
Sun is coming out now, so just in time. So with that, just a reminder that you can come back to our conference webpage early next week, I would say, and you should be able to access all of these recordings and the slides. And please, we do value all of your feedback, so please fill out the anonymous conference feedback survey. And with that, I thank you all. Enjoy the rest of your spring day, and hope to hear from all of you soon.
Thank you much.
Thank
Okay.
you.
All the best, Ken. Gentlemen,
Thank you.
pleasure as always. Thanks for the fun.
All right. Bye, everyone.